Okay, can everyone hear me on the screen? Zelia, you're brilliant. Thank you so much.
You're very welcome.
I really appreciate it.
Have a good day.
Thank you. Wait a minute, now we might be. Now we're repeating. I think log out of this. We're on. Yeah, I'm getting repeating. Can we live with it?
How is that?
Everything I say is going to end up in a loop.
Well, I don't know if it's because I have my phone right here.
Oh, okay. All right. Now that was 15 minutes of billable hours at your rate. So I apologize about that. But if you're ready to get started, I do apologize again about our difficulties. We are having a space crisis among many other crises down here at the courthouse. So thank you for your indulgence. This is the case of Dermatology Associates of Georgia, LLC versus Spectrum Dermatology of Atlanta, LLC, Emma Murad, MD, Susan Spitzler, MD, and Lucretia Reeves, the defendants. This is 2021CV358011. Today is March 8th, 2022. Everyone participating in today's hearing is appearing via the Zoom teleconference platform. However, the court is utilizing its YouTube live stream account, which can be accessed at fultoncourt.org. And if you click on judges and click on my name, and I am Jane Barwick, you can access the YouTube account. Hopefully I will be able to successfully end the YouTube live stream so that it does not stay on YouTube. If it does, then I can have it removed by court admin. It not being the intention of this court that we have an everlasting substitute record, but instead that the public, that we fulfill our very solemn obligation, which we take seriously, to make sure that the public's access to the court's business remains open to it. So with that kind of long introduction, I will welcome you. I think I'm here for an interlocutory injunction. And if there's anything that anyone needs to tell me or say before I turn this matter over to plaintiff's counsel, please do. But otherwise, I have Mr. Hendrick and Ms. Tanner. And for the defendants, I have Mr. Winograd, and do I have Jessica Wood? Yes, I have Ms. Wood.
Yes, Your Honor, my co-counsel is
Brian Wilson and Philip George. I'm not sure who they are, but one at least is sitting in front of law books, so I'm going to take that as a clue.
Your Honor?
Yes.
This is Harry Winograd, counsel for the defendants. It's good to see you. And with me today, besides my law partner, Jessica Wood, and another attorney in our firm, Brian Wilson, we have, on behalf of the Spectrum defendants, looking at the screen from left to right, Dr. Susan Spitzler, if you'd wave just so she knows who's who. In the center is Dr. Emma Murad. And off to the right on my screen is Ms. Lucretia Reeves. All three of them work at Spectrum, and they're here, I guess, remotely at counsel table with me.
Welcome.
Good afternoon, Your Honor. This is Caroline Tanner on behalf of the plaintiffs, Dermatology Associates of Georgia. And with me are my partner, Andre Hendrick, who will be presenting the arguments today, and Phil George, who has just appeared in person, I guess, on Zoom. Thank you for the attention on this motion this afternoon.
All right, is Mr. George an attorney, or is he one of your clients?
He is an attorney, Your Honor. He's an attorney in my office.
Morning.
Thank you.
All right, well, Mr. Hendrick, whenever you are ready.
Yes, Your Honor. Thank you. And I would say that it's our understanding that you would prefer to limit today's hearing to just oral argument. We do have two representatives for Dermatology Associates of Georgia LLC, which I'll just refer to as DAG, available. They're watching via the live stream. And if for whatever reason we need to hear from them via testimony, they could log in. But we figured we would try to keep your screen as uncluttered with thumbnail images of people as possible. Your Honor, as you noted, we are here today on a motion seeking an interlocutory injunction that was filed by plaintiff DAG against the defendant Spectrum, Dr. Murad, Dr. Spitzler, and Ms. Reeves. We are seeking injunctive relief under OCGA sections 9-11-65, as well as 10-1-762A, which is under the Georgia Trade Secrets Act. And Your Honor, this case generally, and this hearing today specifically, is fundamentally about fair competition. Plaintiff has been in business for butting up against 25 years now. It provides dermatological services to patients all over the greater Atlanta area. And over the years, doctors have come and
Mr. Hendrick, may I interrupt with a couple of questions?
Yes,
Number one, I believe I've read and had the impression prior to actually confirming it in writing, but there are no employment contracts here, correct?
That is correct, Your Honor.
And there are no covenants not to compete, correct?
Correct, Your Honor.
Okay, now question of law, is every customer list a trade secret?
Your Honor, every customer list is not a trade secret. However, I would point out that the Georgia Trade Secrets Act specifically identifies customer lists as a possible trade secret, a piece of trade secret information. And in the affidavit that was submitted in support of our motion by Dr. Marcus Stonecipher, we went through all of, we believe, set forth a case established that DAG's customer list does constitute trade secret information. And I would note that in the response that was filed by defendant, they did not take the position that these patient lists did not constitute a trade secret under the Georgia Trade Secret Act.
Okay, so the patients were requesting that their files be transferred over to Spectrum, correct?
Yes, Your Honor, that did occur.
This wasn't surreptitious. There was not any attempt being made to hide the fact that patients wanted to switch.
No, Your Honor, and we do not contend that patients do not have the right to switch from being serviced by DAG to being served by Spectrum. That's not our contention, but that's 2 or 3 steps down the road. If you look at what happened, and this again was not disputed in the opposition brief, Your Honor, in our motion, we identified several dates that on which the defendants accessed DAG's patient files. And if you look at the Amedesis case, which we cite in our brief and which can be found at 793 F sub 2nd 1302, that's a 2011 case before Judge Duffy. And Judge dealing with a very similar situation in the medical industry where you had employees, sales reps from one company leave and go to another company. And shortly before they left, one of the employees downloaded information, sent information, including patient customer lists from their work email address to their home email address for use at their subsequent job. And one of the things that Judge Duffy seized upon was the timing of which that transfer of information occurred. And he found that significant in finding a likelihood that the plaintiff would have success on the merits. And you have the exact same thing here, where you have Dr. Murad, for example, downloading significant amounts of information on Saturdays and Sundays, also downloading information the day before she put her resignation in. And then you go 45 days later after Doctors Murad and Spitzler have left, and you have Ms. Reeves accessing swaths of patient data relating to appointments that had been previously scheduled for Doctors Murad and Spitzler for the remainder of the year.
But the timing that I'm asking about is not necessarily the timing of when the material was accessed, although statutorily I'll give you that that's somewhat critical. The timing is of the preliminary injunction.
Yes, Your Honor.
And so my question was that this wasn't necessarily at some point your clients knew that their patients were going elsewhere. And so my question is, and I'm going to ask ugly questions of the defendants too, trust me. But my question is, why wait so long?
Your Honor, and part of the problem with that is my clients, it took them a while to figure out exactly how to utilize the software that they had at their disposal and figure out that this information had been accessed and downloaded. Because there aren't non-solicitation agreements.
Well, it took me 15 minutes to log on to YouTube. So I'll give you that the technology is the bane of us all, but it took them a year to utilize their software.
Your Honor, and keep in mind that there isn't a non-compete or non-solicitation, as you pointed out, and opposing counsel has. So when they first started getting requests to transfer files, that in and of itself doesn't raise flags because patients have the right to choose what doctors they want. When the numbers started to climb very quickly, that's when it started to raise some red flags. And that's when my client started doing some investigation and calling their software provider and working with them to figure out what sort of searches and queries could be run. And it was only after they got into that they realized that, it certainly appears that this information was improperly accessed. And I would note that in none of the affidavits that were submitted by the defendants did they say, no, we did not go on there. We did not access this information. We did not download it. We did not take it with us to Spectrum, and that Spectrum has not used it. If you look at the specific denials in the responses in the affidavits, Your Honor, they are incredibly limited. And just yesterday, Ms. Reeves submitted an affidavit as part of a surreply. And I think that one is emblematic of how narrow these responses and denials have been. In the motion and then in our reply brief, we point out that DAG has alleged that 45 days after Doctors Murad and Spitzler leave DAG, they contact Ms. Reeves and they say, Ms. Reeves, we left. There's some information that could be very helpful for us, and we would like you to access it and download it. Ms. Reeves goes on DAG's website. She accesses swaths of information, patient data, all relating to all of these appointments that Dr. Spitzler and Murad had already scheduled for the remainder of 2021. And it is our contention that they then use that in some way, most likely to solicit patients. And we point out in our reply brief that defendants did not submit an affidavit from Ms. Reeves, nor did they deny any of these allegations. And so they then file, I believe this morning, a surreply that had an affidavit from Ms. Reeves. And you look at how narrow this denial is. She does not deny that she was contacted by Dr. Murad or Dr. Spitzler. She does not deny that they asked her to access DAG's patient information. They do not deny that she went on to DAG's system and in fact accessed and downloaded this information. She does not provide any sort of a legitimate explanation for why she did so. She does not deny that she provided that information to Doctors Murad and Spitzler. If you really read the denial, Your Honor, it says that I wasn't instructed to access patient data or any other DAG information to solicit patients for Spectrum or for any other reason related to Spectrum. So she wasn't told that she was being asked to solicit it to obtain this information to solicit patient data or for Spectrum. But she doesn't deny any of the other things. And similarly, Even the affidavits that were submitted by Doctors Murad and Spitzler, there's no denial that they contacted Ms. Reeves, that they asked her to access DAG's system, that they asked her to access the patient appointment information. There's no reasonable explanation given for any of it at all. So when you look at
when I first picked this up, I assumed that we would be talking about procedures, medical procedures, techniques, equipment, data. Are we just talking about patient names, or are we talking about patient files?
Well, okay. And so, Your Honor, that's an excellent distinction to make, because once a patient has asked us, I promise I'm trying to get there, Your Honor, that, okay, so the information that Ms. Reeves accessed after Doctors Murad and Spitzler left contained all sorts of incredibly helpful information that could be used to unfairly compete in a variety of different ways. For example, it includes the patient's first name, last name, preferred name, date of birth, their address, their cell phone number, their home phone number, their preferred way of communicating, their race, their gender. It even includes their payer type, which, Your Honor, is incredibly important to doctors, because if they're looking at somebody that has Anthem Blue Cross Blue Shield or United versus somebody that is self-pay or Medicare, different patients have, some are more attractive to healthcare providers than others. All of that information was included in these patient records that Ms. Reeves was accessing the day before she quit. And so that is very different than when DAG subsequently gets a request from their patient that says, please send my file to Spectrum. And at that point, the horse is out of the barn. DAG now has a legal obligation to transfer that medical file to Spectrum so that it can service that patient. And we are not contending.
Does the horse then become monetary damages?
Your Honor.
Once out of that barn?
Your Honor, yes, it does. And it's an excellent point. And I will tell you,
I have two excellent points, but one, go back and answer my first one. Is it just is it just patient names and helpful information, or is it other protected information?
And Your Honor, at this point, the best I can tell you is I don't know.
Okay,
we are still trying to determine everything that was stolen, and we don't know. We know at this point that there was a lot of patient information that was accessed. We're also missing hard files from our office. And, that's a lot of that. That's what discovery is for, Your Honor, is for us to figure out exactly the nature and the extent of the misappropriation. As for your second point about monetary damages, because one of the great things about the Georgia Trade Secrets Act is it arms the court and litigants with a toolbox that can be used for various forms of relief. And so the court has it as its disposal, injunctive relief, which I will say there is one statute within the act that is dedicated just to injunctive relief, which I think supports the fact that the legislature has acknowledged how important injunctive relief is in the context of misappropriation of trade secrets. And then it also has monetary damages. And so what I would say, Your Honor, is with respect to those, let's assume for a second that Spectrum improperly used DAG's trade secret information to solicit patients. And it already has close to 1,000 that have transferred over to Spectrum. With respect to those 1,000, I would agree that DAG is limited to monetary damages. The problem is the hits keep on coming. And that was part of the reply brief that we filed, Your Honor. Since 2022, we're butting up against 100 new file transfers. So this is not something that has stopped. And so with respect to patients that have not yet transferred their files over, we would ask the court to enter an injunction prohibiting Spectrum from continuing to use any of its trade secret information, period. I mean, if Spectrum has any of DAG's trade secret information, they should be enjoined from continuing to use it, including continuing to use it to solicit its patients. We are not asking for some sort of patient clawback. We are not asking the court to tell Spectrum that they cannot continue to service these 900 to 1,000 patients that have already transferred over. I want to be very clear that we do not think that would be appropriate relief. And that Amedisys case, Your Honor, that I cited really is great. It's on point for several different reasons, one of which is that the defendants in that case argued that there would be some sort of, it would prevent the provision of healthcare, and the court said no. And it also raised arguments about that these same sorts of non-competition and imposing restrictive covenants where there weren't any in that argument, which has been raised by opposing counsel. And the court also rejected that argument as well. One of the cases that opposing counsel cites, it was the Hill case, has a great quote in it. It says, fair competition is always legal. And we are not trying to impair or impede fair competition, Your Honor. The problem here is that the evidence certainly makes it look like what we have here is unfair competition, that defendants have misappropriated DAG's trade secrets and have been using it in one manner or the other. And Your Honor, in our reply brief, we had the benefit of some discovery responses that were served on DAG after we filed our motion. And in the responses to the request for production of documents that we received from Ms. Reeves and Dr. Murad, we haven't received the response from Dr. Spitzler yet. Both of them acknowledged that they are likely in possession of DAG's trade secrets, and that once a protective order has been entered, that they would be produced. And Your Honor, I think it's so important when we're talking about likelihood of success on the merits, which, as you know, one of our prongs. You've got to look at what the elements of the claims are. And I think two of the claims that we asserted should really be the focus. And one is the Georgia Trade Secrets Act, and the other one is the Georgia Computer Systems Protection Act. And when you're looking at the Georgia Trade Secrets Act, we only have two elements really there. If you look at the Amedisys holding case, they do a great job of simplifying the elements of that law. And you've got to prove that you have trade. And that makes it pretty easy. And when you're looking at that in this case, Your Honor, the other side, we introduced evidence through affidavits that these patient lists that were accessed by the defendants constitute trade secrets. And there has been no rebuttal to that. That has been undisputed by defendants. And then we have to show a likelihood of success that they took them. And attached to an affidavit that we attached to our reply, we actually have screenshots showing all the different times that the defendants accessed this information and took it. And if you look at the defendants in the Amedisys case, they provided explanations. I was going to work on it at home. I wasn't really taking it with me. I just forgot to turn the manual back in when I left. You have not seen any sorts of you haven't seen any explanations from the defendants in this case.
Is the computer issue that you're talking about right now, is that the Title 16 claim?
I was just talking about the Georgia Trade Secrets Act, but the Title 16 claim, Your Honor, the key provision there, the key language that I would like the court to focus on, it's at 16-9-9218. It's the definition of without authority. And what that includes is if you exceed the scope of your authority, and then that constitutes a violation of that act. So if you have an employee who has the right to access these patient records, that's part of what she does for her job. But in this particular instance, she's called by people she used to work for, and they say, hey, we need you to get this information for us, even though we left 45 days ago, then that would be beyond the scope of her permission. And that would constitute without authority under the act. And that exact point was addressed in that Emeticis case. It was dealing with the federal corollary, the Computer Fraud and Abuse Act. But it's the exact same analysis. And we would contend that when Ms. Reeves obtained a phone call from either Dr. Murad or Dr. Spitzler, who had left 45 days prior, and they said, we need you to go online, access DAG's system and get this stuff for us, then that was exceeding the scope of her authority to access those patient files. And similarly, when Dr. Murad and Dr. Spitzler were going on DAG's system and accessing information for the improper purpose of utilizing it in the future at their new job, then that would exceed the authority, that the scope of their authority to access that information. And that would also constitute a violation of the Georgia Computer Systems Protection Act.
Okay. So statutorily, that particular provision, and I think it's maybe the next section of Title 19, allows for a civil action to arise out of a breach of that particular Title 16 provision.
In Your Honor, I believe there may even be within Title 16, hold on, let me.
Well, I think it's 16-9-93G.
Yes, yes.
Okay.
At the very
But that's
bottom.
not what you've asked for in your petition for an interlocutory injunction, is it?
What do you mean, Your Honor?
Okay, well, I tried to look as carefully as I could at what you were specifically asking me to enjoin. And I've come to the conclusion that you asked me to enjoin continued use of the trade secrets.
Yes.
That this court grant an interlocutory injunction to, one, prohibit defendants from continuing to use, I don't know if you call it DAG's trade secret information, and continuing to solicit that information, to return the trade secret information, destroy their work product, and require them to pay an independent third party. You've not asked, obviously, for damages under 16-9-93. So we're just talking about trade secrets, right?
As far as the injunction, yes, we're not here about damages at all. Now, Your Honor, I believe that we have sought an injunction under OCGA section 9-11-65, which is just the general injunction statute. And so I believe that it would be proper for this court to say that it could enter an injunction under 9-11-65. And when it's looking at likelihood of success of the merits, it would relate to both the Georgia Trade Secrets Act claim as well as the claim brought under the Georgia Computer Systems Protection Act. And in addition to that, you have the specific provision for injunctive relief under 10-1-762A.
Okay. Now, you've talked some, and I heard you, and your, at least your initial motion, I have not read the SIR reply, and I'm sorry. You've talked at least under, or I think you've put in your brief at least some facts as to how you know they took your customer list, but walk me through that one more time.
So, Your Honor, if you look at the reply brief, and there is an affidavit attached to the reply brief,
Okay.
and the affidavit is, there's an affidavit of Deborah Mollahan, and she provides a narrative of the access. And then there is also an Appendix A that is included within the body of the affidavit. And this has examples of when Ms. Reeves and Dr. Murad access the system, where we contend that it certainly appears that they did so with an improper purpose. And based on the information that is set forth in Appendix A, we can look at the types of files that they were looking at and know the type of information that was included. And that is laid out in, for example, paragraph 14 of that same affidavit.
And that's attached to what?
The reply brief.
Whose reply brief?
The reply brief that was filed by DAG yesterday.
Okay. All right, I'm looking for that now. Okay, I got your reply brief filed yesterday. Don't let me get confused here. Again, I'm trying to figure out where this affidavit is.
It is attached to the reply brief.
Okay, I'm so sorry. Whose reply brief?
The reply brief filed by DAG yesterday.
Okay. And it's called Mollahan?
The affidavit is from Deborah Mollahan.
And that's exhibit what?
Let me see.
Because I found an exhibit A, which
Keep
seems
going.
to be some discovery responses. Okay, keep going.
Exhibit B is the discovery responses from Ms. Reeves.
Okay,
And so the affidavit of Ms. Mollahan should come right after that.
okay, got it.
Okay.
Okay, now who is she?
She works for DAG.
Okay, and she says, yeah, they stole it?
In a nutshell, yes, Your Honor.
Okay. Okay. Okay, so when, I guess I'm sort of back to what did you know and when did you know it? Insofar as the timing of the injunction is concerned, because you didn't file for relief until December. And these folks left in,
They left in the last day for Drs. Murad and Spitzler were March 31st, 2021. And then Miss Reeves left in May of 2021. I believe it was May 14th. And then if I remember correctly, my clients did not discover any evidence of them downloading these files until late fall 2021.
and when were your clients sued in DeKalb?
They were sued shortly after we filed this lawsuit.
Okay. So they were sued in DeKalb in December or January?
I
Recently?
believe it was December, Your Honor.
Okay.
And we had a we had a motion, we had a count for injunctive relief in our complaint, and I had an early conversation with opposing counsel about the possibility of a consent injunction in an effort to avoid the cost and expense. I've done that in other cases. And when it appeared that that would not be fruitful, that is when we filed this motion.
Okay. So from March or May, let's say May to December, you did not know that these patient lists had been, you just thought patients were migrating over naturally?
That is my understanding, Your Honor. It was late fall when we first learned that there was evidence that the defendants had downloaded this information.
Okay. So what do you want me to do?
Your Honor, we would like you to enter an injunction. We would like a third party to take an optical image of the electronic devices. We would like everything that either constitutes any information that came over from DAG or that was created using information that came over for DAG should be turned over to defendant's counsel and then produced to us and then destroyed from defendant's possession and system, and then have an audit on the back end to make sure it's all gone.
Okay.
Your Honor, all we really want is for them to stop using DAG's stuff as far as this motion is concerned.
Okay, so third party to take an optical image of the defendant's devices.
Correct.
Okay, then you want it destroyed on their computer.
Correct.
And then what did you say the last thing was?
We would like it turned over to their attorney and provided to us so that we know exactly what all they took.
And other than a protective order, why do you need court orders? You can't get all this in discovery?
Well, Your Honor, we can certainly ask for it in discovery, but getting it in discovery would not, one, prevent them from continuing to use it, and two, would not compel them to destroy it from their system.
Okay. Okay. And how long would you like that injunction to last?
Until an adjudication on the merits, Your Honor. Well, in Your Honor, once everything, if everything happens that we just asked for, so in other words, if an optical image is taken and everything is turned over to their attorney and then destroyed on their system and an audit confirms that it's all gone, there really wouldn't be any other concern at that point as far as the continued use is concerned.
So today's a final hearing.
Excuse me, Your Honor?
Today's a final hearing then.
Yes, Your Honor, I guess it is. With respect to injunctive relief, yes, I think it could be. It could be.
Is the defendant entitled to a jury trial on any factual issues in this injunction?
Not that I'm aware of, Your Honor.
Okay. All right. Who's going to speak for the defendants?
It'll be Harry Winograd, Your Honor.
Okay. If you'd like to go ahead.
Thank you. I previously introduced the people on this call, which are my co-counsel, Jessica Wood and Brian Wilson, and the three individual defendants are on behalf of Spectrum, Dr. Murad, Dr. Spitzler, and Ms. Reeves. The court should deny the motion for expedited interlocutory injunction. Defendants, as we've noted, left DAG 1 year ago this month. Their last date of employment was 3/31/2021 for the physicians. They treated their first patient at Spectrum in June 2021, and DAG transferred 900 patient files to Spectrum over the past year as requested in writing
Mr.
by the
Winograd,
patients.
on page 1 of your brief in opposition to plaintiff's motion for expedited interlocutory injunction filed on March 2nd, 2022, very first page, there's a sentence that says, the injunctive motion was not filed until January 2022, only after defendant physician sued this plaintiff in 2021 for money damages in DeKalb County Superior Court. So this judge swallowed that hook, line, and sinker and assumed that this entire lawsuit was retaliation. So that apparently is not true.
Your Honor, it's not that the entire lawsuit is retaliation in the way that that's stated. However, 2 points on that. First, the quote, expedited interlocutory injunction, today's emergency hearing, is because they were sued for money. It was retaliatory in that for months, the parties had gone back and forth trying to negotiate on the money owed to Dr. Murad and Dr. Spitzler so that DAG knew it was coming. The actual timing, both parties filed suit the same week in different courts as was appropriate for the claims, and service crossed in the mail sort of thing. So I don't think the lawsuit was a surprise to DAG. We had made demand letters. I talked to counsel. I told them we were going to have to sue. We had offered to go to an early mediation instead, and then the parties sued. But the expedited emergency injunction is in response to being sued for money and was an attempt by DAG to make this difficult, expensive, and to try to rush to a final hearing after they waited a year, essentially. So, Your Honor, this is not a matter in need of an expedited injunction. There's no imminent threat of any improper activity. We, at Spectrum, did not take any patient from DAG. Rather, 900 patients chose their medical service provider. Second, the plaintiff failed to meet the burden of proof for an interlocutory injunction that any alleged trade secrets were used for any improper purpose. In fact, the defendants presented 6 affidavits. The SIR reply this morning was the 6th. There are 3 from the Spectrum individual defendants who Your Honor met at the beginning of the hearing, and 3 Spectrum independent marketing vendors. All demonstrate that no DAG duty data was used to solicit Spectrum patients. No DAG duty was requested, none was used, period. And we're going to go through those affidavits on this call. This motion, as the judge asked with the first question of the day, is an attempt to have the Fulton Superior Court impose restrictive covenants where there is not any contract that the parties agreed with non-competes, non-solicitation, or non-hire provisions. But before we get into the substantive response, the court should note the following. This expedited motion was filed a month after the physicians from Spectrum sued DAG and DAG's managing member, INDICAB Superior Court, for compensation owed from their departure a year ago. Since this case involves thousands of patients and patient files, including the 900 patient records that DAG transferred to Spectrum, discovery has some complexity. There is a need under the statute for a protective order to observe the HIPAA rights of the patients and the content of these alleged trade secrets, various business records, computer forensics on both sides. Some protective order needs to be negotiated, and I would imagine with good counsel on the other side, we could hammer that out and present it to the court. But as but one example, if you would pull up the request to produce the Spectrum 63 to 66, I want to show something to the court. If you're able to access the screen, just one moment, Judge. If you would move to number 63 to 66. So what we're looking at here, Your Honor, are discovery requests from DAG to Spectrum, and just these items, 63, 64, 65, and 66. Any and all patient appointment schedules for Dr. Murad's patients from June, obviously, through now. Number 2, Number 64 on the page, any patient appointments for Dr. Spitzler's patients. 65, any documents reflecting the appointment schedules for their patients since June of 2021. And 66, schedules for Dr. Spitzler's patients since that time. This concerns HIPAA-protected information about all of Spectrum's patients, not just the 900, all of our patients. Perhaps they were former DAG patients who were properly solicited using marketing professionals who were hired and paid for by Spectrum. No trade secret was used. Perhaps they're patients who've never been seen by DAG but came to the Spectrum's new office. But DAG is using this litigation to force our clients at Spectrum to reveal their patient identities and contact information. DAG seeks relief here today for which it is not entitled. Final point before we get into the substantive response. If you'd close that screen, please. Given the two court cases and the complex discovery issues, defendants requested in our reply brief and renew here today that the court send the parties to mediation, either to resolve all claims in both cases, or B, to negotiate discovery issues with the help of a neutral. Now, by way of a substantive response, this matter is not appropriate for expedited interlocutory injunction. The injunction statute has 4 prongs, 4 requirements. You'd pull up that, please. First, that there's a substantial threat that the moving party will suffer irreparable injury if the injunction is not granted. What irreparable injury now forward after a year are they likely to suffer? Instead, the irreparable injury would be the interference with Spectrum's practice of medicine a year after they left, which is number 2. The threatened injury to the moving party, DAG, outweighs, keyword, outweighs the threatened harm made due to the party being enjoined, Spectrum. 3, a substantial likelihood the moving party will prevail. And 4, granting the interlocutory injunction will not disservice the public. Now, it's interesting, we've heard a lot about this Amadeus case, and they use it for the point that it's in the public interest, somehow, what they're seeking today. But, Your Honor, that case says it is in the public interest to prohibit the solicitation of patients from doctors when such solicitation involves the improper use of trade secret information. There is no evidence of that here. Plaintiff failed to meet that burden. Spectrum did not improperly use data for the benefit of Spectrum. Latches bars their claim. They're a year late. And the key fact is no DAG data was used for Spectrum's solicitation of patients. Rather,
do you have a response, and or have you responded, and or does it matter to the, let me get it, the affidavit that we were looking at, the Mollahan affidavit, which essentially says we looked at NextGen and they were copying all these files the day before they left?
Yes, Your Honor, we have in our affidavits that we'll go through in my presentation address that issue. The short answer is the 3 individual defendants deny the allegation, and we'll get into that. Rather than using the DAG data to solicit patients, our defendants prepared to open a new medical office. They're allowed to prepare. They hired professional independent marketing vendors to launch Spectrum without using any DAG data. And now's a good time to address the court's question, and we can get into these affidavits. Let's do the Banco affidavit first. There's 6 affidavits, Your Honor. It'll take a moment. So Exhibit 1 to our initial reply is the affidavit of David Banco. You can see here standard form affidavit. If you'd continue, please. All right. For the last 20 years, he's been the president of DART. And DART is in the business of providing direct mail and other marketing support for business. Primarily, he works with medical and dental practices, and approximately, at one point, 70% of DART's clients were medical and dental. DART never performed work for DAG, so we found an independent vendor. The DART expert professional says in number 8, based on my experience, approximately 80% of patients will come from within a 5-mile radius of a medical practice. So, DART was engaged by Spectrum to work with DART's data compilers to determine single-family dwellings within 2.5-mile radius of Avalon, a shopping retail area, and within 5 miles of Spectrum's office. Other criteria were used, as is typical in DART's business, related to income, age group, and race. Next page, please. DART prepared a postcard announcing Spectrum's Alpharetta office was opening, mailing the postcard to 15,000 single-family dwellings. Spectrum in number 11 paid DART $8,850 for the services. DART created a consumer database list count report, March 2021, that showed 35,928 eligible homes within the criteria. Spectrum signed DART's priority order form in May. Spectrum asked DART to refine the criteria to a smaller number of homes. DART created a consumer report in May down to 17,050 homes. Next page, please.
Does that stop, Mr. Winograd, just out of curiosity? So the argument is conceivably, the argument is, well, we took the list, but then we hired somebody to come up with customer lists, and so we came upon it legally. Is that a good
Not quite, Honor. Not quite, Your Honor. The argument is different. There's a dispute in this case about what is a trade secret. Trade secrets have to be protected in a certain way, etc. The court asked early on, are all customer lists trade secrets? No, they are not. So the things, when we went into access things, and we admit in all the affidavits, we regularly, daily access these files while we worked at DAG. So we'll get into this in a moment, but the argument is we did not, and there is no evidence to suggest that we ever used any data they contend is a trade secret. And in our earlier discussions with opposing counsel, we said, what do you contend were the trade secrets? And they said, well, things like an appointment calendar. And I said, I don't know if that's a trade secret or not specifically, because the patients have a right to choose. The patients may have a right to come in for their appointment and see a different doctor. I don't know. Let's identify what are the trade secrets. That is a hotly debated issue in this case. But we contend, and under oath have stated, we did not use, we did not ask anyone else to use, and we did not instruct anyone to take any DAG data to use for any purpose at Spectrum. Certainly not to solicit the 900 patients. And we're going to show you how we got to the 900 patients. So Walking through this affidavit, DART mails tranches of 5,000 postcards in May, another 4,600 in September. Look at number 20, Your Honor. DART did not provide Spectrum with the information about the addresses used. DART just went and did it. DART created rack cards, which are like referral postcards that referring physicians can give their patients. They're printed pieces. DART also created referral pads to give to physicians. So this was a marketing thing done by an independent company. Next page, please. At the top, 23. Spectrum did not inform me, DART, or provide me with a list of names or specific street addresses to which I should mail the postcards. DART mailed one postcard to Spectrum at their office so they could see it, and the rest was pursuant to the typical procedure to allow the client to see the finished product. Spectrum requested mailings to specific zip codes within 2.5 miles of Avalon and Windward, two neighborhoods, two areas. And DART says, I would have suggested those geographic areas anyway due to proximity to Spectrum's office. DART mailed postcards solely to single-family dwellings identified via DART's investigation. Now let's go to the exhibits for DART. The first is the Postcard Mailer. It's a standard promotional mailer. That's the front and back. It shows Dr. Spitzler on the left with a green, emerald green shirt, Dr. Murad with the black top, both under their white doctor robes. On the next page shows where to find them. Next, please. The direct mail order form. Look at the date, Your Honor, the date of the order, April 30, 2021, after Dr. Murad and Dr. Spitzler left. Next exhibit. This is just the contract that they entered into. The electronic signature form that goes with it to show when they signed at the end of April and in May. And now this computer database we mentioned. If you look at, pull up please. This shows zip codes, stuff, how many total homes were available, adults, ages in 2-year increments. It's an analytics tool that shows how they sorted demographically who to mail announcements to.
Okay, well, I still have my question, I clearly kind of posed it inartfully. I give you that. But if one comes upon, or if one has in one's possession, this is a hypothetical, if one has in one's possession stolen material, and one walks down the road and finds the same thing, or pays someone for the same thing, is the first material not stolen?
I believe that, respectfully, Your Honor, it's an incorrect formation of the question. Stolen.
Or is the question, which set did they use, which kind of sounds like a fact that hasn't really been ruled upon or adjudicated?
There is no evidence, no positive evidence that they used any of the data to solicit patients, and there is affirmative affidavits, 6 of them, that they did not use it.
Okay, well, is that a determination of fact that needs to be decided by whom? The court or a jury?
I believe, Your Honor, that would require discovery and a trial, and whether at the trial, depending on what the issues end up being, something was or was not a trade secret turns on various points. You asked some earlier, but there are lots of things that might be a trade secret, depending on how it's handled. But if you can find it elsewhere and others can find it in public data, it's not a trade secret, Your Honor. There's nothing secret about it. It's public data. We didn't go out and develop this list. An independent vendor did. They're the other side. DAG wanted this expedited hearing. They have no evidence other than Ms. Mullahan's, quote, belief that things were used to continually solicit patients. Okay, the belief isn't enough. There's no evidence, and in fact, there's testimony of a denial of that in these affidavits. If we could continue, please. So as you come down, just keep going. So there was the initial report that showed 30-some thousand possible homes and can continue. And then they whittled it down with some new filters. But all of this information about who got the mailers is provided in this exhibit. We can move on to the next exhibit, please.
Did the defendants, did Spectrum and the individuals file a counterclaim or just an answer?
Just an answer, Your Honor. Our claims are over in DeKalb.
Okay, and have you asked for a jury
Yes, Your Honor.
here in Fulton? Okay,
I believe so, Your Honor.
all right.
Next is the affidavit of David Burl. It's the second of the 6 affidavits. If you go on to the next page, please. You'll see in paragraph 4, David is the president of Find Local,
Okay.
and Find Local is a website development company. He's been the president for over almost, 15 years. 60% of Find Local's clients are physicians and physician groups. He has never performed any work for DAG. He's independent. He was engaged by Spectrum to create its website. Spectrum provided in number 9 3 things: photos, a logo.
Mr. Winograd,
and
I think this is
physician-
wonderful. Are we still on the DART affidavit?
No, Your Honor, this is the second one, Find
Okay.
Local.
Okay, Find Local. Okay, great. Before we go on, let me just ask, and I want to get input from both parties. How do you intend, and I'll start with you, Mr. Winograd, because you were talking. How do you prove what was on the opposing party's computer? Mr. Winograd, you want to answer that question? Then I'll ask Mr.
Well,
Hendrick.
I mean, I know one could prove sources of data, but as just an example, Your Honor, there is data legitimately in our possession that is used in the DeKalb case that were reports provided by DAG to Dr. Spitzler and Dr. Murad regularly about their performance and economic situation. There's nothing trade secret about that report, but I suggest, based on the overbroad interlocutory injunction that opposing counsel seeks, they would contend we're not supposed to have that information. It was provided to us. We kept it knowing we were going to need it. So how would I figure out where it came from? I suppose a forensic computer person can track that.
All right. So
But
what?
it's not
what would you-
appropriate
what would
for an
you-
injunction.
Okay. What do you need? Well, I guess I'm asking you to prove a negative, but don't
Not my
move.
burden, Your Honor.
Okay, Mr. Hendrick, what do you need? You asked me for an optical image and I have by a third party, and I have no idea what that is. So tell me what you need to show they took stuff from your computer contrary to Georgia law.
And broadly speaking, Your Honor, I need discovery. But as far as specifics, if a third party goes in and takes an optical image, that would basically lock in time everything that was on their devices, making sure that nothing was spoliated moving forward. And then during the course of discovery, we would be able to go through that information to determine through both that and other discovery tools such as depositions, exactly what was taken from DAG. And then we would be able to figure out exactly how they were using it, which would help us formulate our theory on damages, which we are seeking in this case. And I want to be clear on that point, Your Honor, because earlier you talked about this possibly being a final hearing. We do have damage claims that would still be pending regardless of the outcome of the hearing. And then on the back end, that's why we asked for an audit where someone could go back through their electronic devices and ensure that they did not still have anything on their devices that either they took from DAG or that they created using something from DAG.
Prior to filing suit, did you send them a spoliation notice?
Mrs. Tanner is shaking her head yes. So
Yes, Your Honor, we did.
When?
And I'll state in my place, Your Honor, I told the clients the same thing. Don't change anything.
Okay.
But that's not a risk of imminent harm or anything of that sort. Discovery is needed in the case, but however, there is nothing to support the interlocutory injunction.
Okay,
and
I get
certainly
that
not.
point. I'm trying to figure out where we go from here. Do we have a, I don't want to misuse the term metadata, but do we have a computer forensics case here?
No, Your Honor, what I think we have here.
Whoa. We have the invocation of Title 16, which sort of by its nature starts talking about computer usage and improper computer usage and computer interference or whatever term it uses.
Yes, Your Honor.
What is needed to, I don't want to have another hearing. What is needed from the court to get legitimate discovery from the other side? Hey,
Your
Mr.
Honor,
Hendrick,
what
you
we-
go first. Mr. Hendrick, you go
Okay.
first, please.
And Your Honor, I think what we've asked for will get to that point, which is because once we have an optical image, that gives us something that we can work with.
What kind of intrusion does that cause? What does one have to do?
You have a third party that shows up wherever the defendants have their electronic devices, and it'll take probably a couple of hours. These vendors, I had this done in my cases. We routinely do this for our own clients where we want to maintain information. You have them show up. In fact, sometimes they can even do it remotely.
How much does this cost?
It depends on the particular instance, Your Honor. The amount of data, the amount of time.
All right, well, give me an estimate.
Your Honor, and this is going to be a low ball because the last time I did this, it was I was sending out a vendor to do one party's phone. And so I can tell you that it was in the hundreds, not thousands of dollars for them to go and take an optical image of a phone. Now, I don't know off the top of my head how different that becomes when you start talking about entire hard drives versus just a phone.
Okay.
Your Honor, may I be heard on that?
Yeah, in just a minute. All right, so you want a third party to come in, I'm assuming with a protective order, and take an optical image of the other side's computer limited to a period of time, correct?
Yes, Your Honor.
All right. Okay. What do you need, Mr. Winograd?
Your Honor, what we need is a conference with opposing counsel to set up routine discovery. Somehow this hearing today has turned into a discovery conference, which is fine with us, but what we need is if the plaintiffs want to do these things, we need a protective order, because if they take a byte-by-byte image of Spectrum's computers, there's a lot of stuff in there that they have no right to see. And it's not just it's all of our patients, not the 900.
Oh, okay. I've confused myself. Mr. Hendrick, is the computer that okay, I see what I've done. The computer that we're talking about is the plaintiff's computer.
No, it's the defendant's computer.
Okay, no. Who did the stuff come from originally?
Well, it came from...
Take a picture of your own computer, Mr. Hendrick.
Well, Your Honor, the problem is identifying what information the defendants are in possession of. And
Maybe, but first, how did Halloran or whatever the name is come up with? There was some data associated with that. But when you're talking about pulling down appointment lists and pulling down patient data, you'd have to compare it to another day. I mean, you're saying, okay, the day before they left, they took all this stuff. Well, did they routinely take all this stuff? Did they take it the day before? Did they take it the week before? I mean, you have to have some comparator. Take a picture of your own computer.
Your Honor, we have that. I just don't think that really, you asked me what I need as far as in this case. And the answer is I need an optical image of defendant's computer, because what is at issue is what they have misappropriated, what they have in their possession. That's the second element of the statute. You have to have a trade secret and it's got to be misappropriated. It doesn't help me at all to take a picture of my computer. DAG already knows what's on its computer.
Okay. All right, anything else?
Yes, Your Honor.
What is it, Mr. Winograd? Because I don't need you to read through any more affidavits.
Thank you, Your Honor.
Okay, anything else?
Yeah, I have something else, Your Honor, but I want to make sure that Mr. Winograd is finished. I don't want to.
Go ahead, Mr. Winograd.
All right. So anything else? This court should deny the injunction.
Okay.
And the key thing is Georgia's OCGA 9-5-8, which says, well, the judge has the power in the sound discretion of the judge to issue an injunction. The power should be prudently and cautiously exercised and, except in clear and urgent cases, should not be resorted to. This is not clear and it's not urgent. They waited a year and we dispute what are trade secrets here. The key for the court is to preserve the status quo. Us disgorging or them spelunking through Spectrum's business computer is not preserving the status quo. Now in discovery, sure. And we said at the beginning, we request the court send the parties to a mediation to either work on resolving the cases combined or work on a discovery protocol, including the necessary protective order. But the law, the HIPAA rules, among others, require that we do this, or we have to go to each of the 900 patients and get their permission. And there's another large number of patients involved too. I don't think it's in anyone's interest to get all the patients involved here, and I don't think it's necessary. In those other affidavits, the three individuals each deny the very thing that Andre Hendricks said here. They deny that Dr. Spitzler or Dr. Murad called for the patient appointment data after they left DAG. They didn't instruct anyone. They didn't ask anyone to do that. If Ms. Reeves did something along those lines, I don't know if it's a trade secret or not, but if it was, she did something of her own accord, and everyone states in their affidavits 4, 5, and 6 today, that they did not use that or any other DAG data to solicit patients. That's not what happened here. And the reason that plaintiffs are going for this expedited injunction, you said retaliation, but they were doing it because they don't have discovery. They have nothing to show yet. It's premature, and today this court should deny this request for an interlocutory injunction.
Okay,
Thank you.
Mr. Winograd. I appreciate that. All right, Mr. Hendrick, I'll let you close us out here.
Thank you very much, Your Honor. I appreciate it. one of the things I want to talk about real quick is these marketing vendors. And it's a red herring and it's irrelevant. Your Honor started to touch on one of those points earlier, which is just because Spectrum utilized these marketing vendors does not mean that they were not otherwise utilizing improper trade secrets that they had obtained for DAG, either for the purpose of soliciting patients or for some other purpose. And also, and we point this out in our reply brief, Your Honor, which you may not have had time to review yet, but the timing is problematic. If you look at all of these marketing activities, on the one hand, Spectrum says that they started getting these requests for patient transfers in April 2021. But none of these marketing efforts took place until after April 2021. If you look at the mailers that DART sent out, that was in May. If you look at when Spectrum launched its website, that was in May. Spectrum didn't open its doors until June. So everything that Spectrum is pointing to saying, no, we did it right, is occurring in May and June. But they started getting these patient requests in April before they did any of that. So there are certainly questions there. In fact, all of these affidavits, they raise more questions than they do answers. And that brings me to another point, Your Honor, which is opposing counsel's focus on use. And that's such a critical point here, Your Honor, because use is not even an element under the Georgia Trade Secrets Act. In order to succeed under the Georgia Trade Secrets Act, we have to prove that we had a trade secret and that they took it. There is no use requirement to establish a claim. And Your Honor, I think is in one of Shakespeare's plays where the line is, I think, she doth protest too much. And here opposing counsel has argued repeatedly and throughout the entire hearing that they have not utilized DAG's information to solicit patients. And that's important for 2 points. Number one, it almost always has the phrase to solicit patients on the end of it. You don't hear opposing counsel say that they did not actually download the information. You don't hear opposing counsel say that they did not bring the information with them. You do not hear opposing counsel say that Spectrum did not use any of the information. What you hear consistently from opposing counsel, and if you go back and you look at these affidavits, what you see is that phrase to solicit patients used almost every time, which raises the question, well, how else are you using DAG's trade secret information? And Your Honor, we don't know that.
How many doctors are left at DAG?
Oh, I know that they employ approximately 85 people, Your Honor, and I believe that there is more than 5 doctors there. There may be more than 10 still there.
Okay.
And they have 5 locations around Atlanta, Your Honor. So this isn't something that is, this is still a thriving practice. And so, Your Honor, again, opposing counsel keeps talking about that this information has not been used to solicit patients. At this point, we should not be required to prove use. That's what discovery is for. What we have to show at this point to establish that we are entitled to interlocutory injunctive relief is a likelihood of success on the merits. And when you look,
Madam Court Reporter, can you hear him? Is it I who have frozen or is he frozen?
No, it sounded like his sound went out.
Mr. Hendrick, try again.
Can you hear me now?
The last thing I heard you say is that you shouldn't be required to prove use.
Your Honor, we have not received one document from the defendants yet. We have not been able to depose one of them. There is just simply no way where it would be proper to force a plaintiff in a case such as this to establish use at such an early stage of the case, especially where use is not even an element that has to be proven to succeed on a misappropriation of trade secrets claim. And if they are not, if defendants are genuinely not using any of DAG's information, then there is no harm to them by entering this injunction. It would not alter the status quo at all. If you entered an injunction that said, defendants, you may not use any of DAG's information that you took with them, and they were not using them, it would not affect their life one bit.
Okay, I'm
Your Hon-
going to announce an order, and then we'll decide who's going to prepare it. And so everybody start taking notes. The request for an interlocutory injunction is denied. Now, it's either way premature, as Mr. Winograd said, or it's way too late. I'm not sure I can answer that question right now, but it's not appropriate. Number 2, agree on a protective order for any information you obtain from each other. If you cannot agree, send us your last best version in Word. We are going to order you to mediation. My concern is just, is it too early? I was very much hoping that I could help in trying to make, not affordable, that's ridiculous, but in trying to make efficient computer information from both sides. And I just ended up confusing myself. I understand that information has been submitted to the court, that this is what's been taken from the plaintiff's computer, and this was when it was taken. But that's not necessarily all the information. That was a targeted time period that it looked like it pertained to facts in the case, like somebody's last day, for example. So I just ended up confusing myself. I guess the issue is that information is needed from the plaintiff's system, and information is perhaps needed on the import side of the defendant's system. It is ridiculous to say that you're talking about hundreds of thousands of dollars. I think you're talking about at least that, because I may in fact appoint a special master to look at all this information through the HIPAA lens. And when we get into that, I don't know how big these practices are. I hope all doctors make a lot of money and are happy, but I don't know that there's enough money for what may be coming and what a special master might do in this instance. So you tell me when you want to start talking seriously, and I'll enter the mediation order. I think it's too soon. I don't know what's going on in DeKalb. I don't think everybody has suffered enough yet. I don't think you've said enough ugly things about each other enough. Breaking up is hard to do. So help me. When do we do a mediation order?
Your Honor, at this point, we still need discovery. I mean, we need to investigate.
See, you haven't suffered enough.
Your Honor, we would be going in blind, and this is what we put in our reply brief. We are seeking monetary damages, and we have no way to quantify those at this point.
The jury may recommend, the defendants incidentally have asked for a jury trial already. So a jury may, Ms. Cummings and I just had a jury trial in which the issue was a permanent injunction, and the jury determined the facts and then presented the findings of fact to the court. And I believe that's the proper way to do it, where there are issues of fact as to whether a permanent injunction should be interposed. Okay, Mr. Winograd, do you want to say anything about when we should go to mediation? That's the limited question.
Yes, Your Honor. It is my request that the parties go to mediation in the next 60 days, subject to the schedule of an appropriate mediator, and that would include both the discovery issues and perhaps, hopefully, the business issues too. For the court's information, there's a significant amount of money at issue in DeKalb, but the process we're all working on, and even through today's hearing, is going to overshadow that by a long shot if we take both cases to trial. There's a lot of lawyers on this call. The doctors had to step away from their practice to participate today and to watch a case that matters to them. So I would ask that we go to try to get on a calendar for an early mediation within 60 days. I think we have enough information for that conversation. And however, if I can't make them go, you can. I can't make them go. And if they're not ready to go, then I know what to do next, and we'll do it.
When, Mr. Hendrick, if not extended, and this court civil docket is pretty up to date, when is discovery over?
On a 6-month track, we just received the first answers, which would have been 45 days after service. We're still not even 45 days after Dr. Spitzler was served.
So we're talking about August, really, before.
Yeah, yes, right.
Correct.
And like I said, I mean, we don't have, we haven't even gotten interrogatory responses from Dr. Spitzler. We haven't gotten a single document.
Okay.
Which is why we would love to do mediation. We would love to do an early resolution to this case, but we can't go in blind. That's just going to waste everyone's time and money. We're throwing darts at a board as far as what our damages would be.
Okay. We're going to get a schedule. Jessica, have we done a scheduling order? Okay, we're going to do a scheduling order. The scheduling order will give you it will actually give you a trial date.
Okay.
It'll give you a discovery ending date. It'll give you a dispositive motion date, and it will give you a mediation date. And all I can tell you is we send out what I think are good scheduling orders. We stick to it. You'll be on trial before you know it and way before you're happy. And I wish you the best of luck. I wish I could help.
Thank you, Your Honor.
Okay. And if you think I can, then let me know. I'm always available via a teleconference or Zoom, certainly. And good luck.
Thank you, Your Honor.
Okay. Thank you. Everybody was real good. Okay, Ms. Jessica Wood, are you still there?
Yes, she is, Your Honor. We'll put her on
Ms. Jessica
camera.
Wood, I'm gonna assume you and Mr. Winograd, you prepare the order. Thank you. Circulate it to everybody and let's get it going. All right.